before your lordships, although Claimant's before Mr. Justice Jacobs. I will, on the whole, refer to them, if I may, as charterers, but I accept that that is potentially tendentious. But
all right. Well, we'll live with that degree of tendentiousness.
Your lordship knows me well enough to know that there will be no further tendentiousness. Now, it was, however, the conclusion of the learned arbitrator, Mr. Fitzpatrick, subject to the judgment of the court. And this appeal is brought with the leave, and it is leave under the Act still, of Mr. Justice Jacobs under Section 67. The appeal relates discreetly to the charterer's proceedings under Section 67 of the Act, and is exclusively related to the jurisdiction of the arbitrator. It's not an appeal under Section 69, and that may be of some importance, because obviously for the purposes of Section 69, the parties are bound by the findings of fact of the learned arbitrator in the award, which I will briefly show you. For the purposes of Section 67, as my Lord, having expressed the principles of Section 67 that everybody else has since followed, your Lordship will know that it's a de novo hearing with some exceptions, but it's de novo. And there is potentially rather a...
Well, if the arbitrator's factual findings are different from the judge's factual findings, you'd better point out in due course what the differences are.
I shall do that.
In case we get to Section 69.
Yes, I will. Well, we can't get to Section 69 because the learned judge didn't give leave against his grant of leave, and he therefore didn't decide the Section 69 issue at all. Perhaps I can just show your lordships the order, and it may be of some importance. It's a page, tab 6, page 42 of Part 1. Your lordship will see that the learned judge ordered the final arbitration award of Stuart Fitzpatrick is set aside pursuant to Section 67. The claimant is granted leave to appeal to the High Court on its application under Section 69. The defendant has leave to appeal against paragraph 1 of this order. But the learned judge did not, although he said what he would have done if he'd been hearing the appeal. And of course, as your lordship knows, these days, the judge who hears the substantive appeal isn't the judge who grants or grants leave. So he never made any orders under Section 69 on the appeal. And this may be of importance for a reason that I will develop before you. But that's why I say it's an appeal only under Section 67. And of course, he didn't give leave to appeal against his grant of leave to appeal under Section 69. And as your lordship knows, I can't now challenge that. So there is a grant of leave to appeal, but there is no appeal that has currently been heard, and therefore none before your lordship.
So you say if we allow the appeal on Section 67, we have to send it back to the commercial court, leave under Section 69 having been given, so that if we send it back to Mr. Justice Jacobs, it won't take him very long. And if we send it back to any other judge, they can...
Well, it should go back to another judge. There's the recent decision of Mrs. Justice Cockrell, who's currently the commercial judge in the CBLC case, which says that it is very rare that the judge hearing the appeal should be the same judge who hears who grants the application for leave to appeal. But the answer to your lordship's question is, in principle, yes. Although I will explain to you if I may, in a little bit after I've explained my case, why that may or may not actually be so. But it's in principle, yes. Now, it is, because it's critical at the outset that the point before your lordships is not, as my learned friend proposes, whether the parties concluded a legally binding charter, but rather what tribunal should, in principle, decide that issue and make appropriate findings of fact. So it's a question of focus on what the point in issue is. So you are not here to decide whether there was a condition precedent to the Charter. You are here to answer the question of whether the undoubted agreement to arbitrate was a relevantly, a legally relevant arbitration agreement. Because there was undoubtedly an agreement to arbitrate, as I will show you. The question is, what is its legal character?
The more times you say there was undoubtedly an agreement, Mr. Young, the more I tend to think that there may be some room for doubt about it.
Well, I'm going to show you that not only is there no room for doubt, but it's common ground between the parties. But put it this way, my lord. The parties agreed the terms of whatever it is I mean,
what is common ground is that if, or what was agreed was that if the subject was lifted, then the contract which would come into being would contain an arbitration clause.
That is the way that my learned friend puts it. That is, as I will show you, quite contrary to what the House of Lords held in the Fiona Trust. And I will, if I'll be forgiven, spend a little time just addressing you on the Fiona Trust, because everybody thinks they know what it decides. It's only when one actually concentrates upon it that I think one can see the true extent of what the House of Lords decided.
Yes.
I'm sure your lordship will forgive me for
no, I look forward to being educated or re-educated.
Well, I hope it's re-educated, but whichever it is, I hope your lordship benefits from it.
Mm-hmm.
Now, you've got the judgment and you've had the skeletons. Can I just make one point? My learned friend, Mr. Holroyd, says that I accept the judge was right in his analysis of the subject of shippers' receivers' approval. I do not accept that he was right. All that I say is that on the assumption that that was the correct analysis, even so, it is not enough for Section 67. I do say, however, he was wrong for reasons which I will develop briefly. So there are essentially two questions before your lordships. There is a question of construction and a question of policy. And whilst your lordships may have thought that this was one of the most uninteresting cases to the public, your lordships will see that we have a full house today, and I think your lordships know that it's the LLM course from the LSE.
Yes. Your
lordships, I'm pleased to say...
Well, it's a public hearing, and we very often have members of the public come to see justice done.
I think Alan Bennett once expressed it very nicely, but that's for another occasion. But your lordships might know that by what everybody except possibly President Putin would call an overwhelming majority, the LSE LLM course thought the learned judge was wrong. You will doubtless educate or re-educate them accordingly, but no pressure. But they're here with an interest to see, first of all, how argument progresses before your lordships, and then...
Right, well, we better get on to it then.
We better get on. I shall, my lord, yes. Now, the issue of construction is of the terms agreed between the parties as expressed in the broker's recap. And I put it, I hope, untendentiously, as the terms agreed, because they are absolutely plain. That the broker's recap, which I will show you a little bit later, is at bundle 2, tab 2, pages 9 and following. And that they did agree those terms is common ground. The question is whether the subject, whatever its impact may have been upon the charter fixture, was a qualification of the parties' agreement that disputes between them arising out of their relationship should be resolved in arbitration. Even if it was a condition precedent to the charter fixture, which I do dispute, was it a condition precedent to the operation and applicability of that agreement to arbitrate such disputes? And I might say, because this is a point made by Lord Hoffman in the House of Lords, what is the relationship, if any, of the approval of the vessel by a third party to the charterer's agreement to arbitrate disputes? You, my lords, are commanded by the House of Lords to answer that question. My learned friend would say, oh, there's a clear relationship between the two. I say there is none at all. The issue of policy is how the courts reflect the desire to encourage arbitration and to reduce unnecessary parasitic satellite litigation, and how should the courts approach applications under Section 67 of the Arbitration Act in cases such as the present, where one important issue, probably the dominant issue between the parties, is whether the nominal charterers had a defence to a claim for damages for repudiation based on the argument that the undoubtedly agreed terms did not become legally operative. Although issues about the underlying enforceability, legal character of the what's called the matrix contract may take different forms. Subjects are but one example. There are others, whether there was an offer that was validly accepted, whether there was consideration, whether there was a mistake, a fundamental mistake, whether there was a misrepresentation avoiding the contract, or duress undermining the agreement, or, I want to say, bribery. What should be the policy of the courts under Section 67 when there are different related disputes arising out of the same essential factual context, some of which would be plainly arbitrable, some of which go to the legal character of the matrix contract? Are some disputes to be resolved in arbitration, and others, even though closely, even intimately related, by the courts with an inevitable two-stop process? And it is pretty much an inevitable one. Now, bringing those construction and policy considerations together, essentially, should arbitration agreements sink or swim as a matter of jurisdiction according to the validity of the main agreements in which they appear? That was the view of the learned judge. That is distinctly not the view of the House of Lords, as I will show you. Indeed, the House of Lords, in my submission, when properly read, deprecate the sink or swim approach. You will know that the subject of Section 67 and 69, well, indeed, the whole Arbitration Act is currently before the Law Commission. One of the principal areas of focus of the Law Commission is on how Section 67 works. Your Lordship's judgment, I feel very confident in saying, will greatly illuminate the Law Commission's involvement in this particular area, and I could safely say that, having been speaking to them about it. So they are anxiously awaiting your Lordship's judgment. Now, my submissions before your Lordships will take 5 steps. The first step is that I will set out some critical propositions of law. The second step is I will show you the basis in statute and authority for those propositions, and some ancillary authorities which may bear upon it. The third step is, having established the criteria for construction, having established the basis for those propositions, I'm going to show you the essential factual material so that you can apply you can consider those factual materials in the light of the authorities and the propositions I've shown you. The fourth step will be I'll show you the judgment and show you precisely why the learned judge was wrong as a matter of law. And lastly, I will consider some points in Mr. Holroyd's skeleton which will not otherwise have been dealt with through those steps. Now, the first step is the propositions, which I'm going to advance before your lordship. There are 5 in number. They are the analytical ingredients of the presumption of one-stop dispute resolution, which Mr. Holroyd complained in paragraph 31 of his skeleton, but I didn't make clear what I say the content of the presumption should be. So I'm going to make it clear to your lordship. There are 5 propositions. The first is where parties have made or purported to make an agreement containing an arbitration clause, in construing and applying that arbitration clause, the court should start with the presumption that the parties, as rational business people, intended that all disputes arising from their relationship, that's the word used by the House of Lords, thus created, should be determined in a single arbitration, even if some of, or indeed all of those disputes, were as to the very existence and validity of the main agreement. That's the first proposition. It's the presumption, it's the starting point for any analysis of construction.
When you say make or purport to make an agreement containing an arbitration clause, do you mean purport to make a immediately legally binding agreement? I mean, because you, throughout your submission so far, you've been using the word agreement without attaching the words legally binding to it.
And that's why I use the word agreement rather than contract.
So you say they purport to make a non-legally binding agreement with an arbitration clause. Should I write where the parties make or purport to make a non-legally binding agreement containing an arbitration clause? I mean, is that the submission?
No, that's not the submission I make.
So do I put in
you're writing in
legally binding agreement?
An agreement, whether legally binding or not. I think it's that's why I put in the word purported. So I suppose the question, your lordship, is I'm trying to put forward the proposition, although my Lord Justice Males may think it tendentious, that does not make any assumptions about that. They made a fixture. Perhaps I can put it like that. And undoubtedly, I can't use the word undoubtedly, the parties did agree the terms of a fixture.
Well, we agreed what terms would be included in a legally binding contract when it is legally binding. But it doesn't mean that we have agreed those terms in a legally binding way at the moment.
I'm trying not to make an assumption. So
Can we test my lord's point in this way? Suppose the parties actually say to each other, if we conclude an agreement, there will be an arbitration agreement in it. In those words, have they made or purported to make an arbitration agreement in your language?
Not in the words that you have used, my lord, no.
No.
If we make an agreement, there will be an arbitration agreement. That's the question I'm answering, my lord. However, if, as is in what I'll call the broker's real world in chartering fixtures, we make an agreement with subs, and that agreement contains an arbitration agreement. The fixture contains an arbitration agreement. Whether the fixture is binding or not is to be decided, and I say is to be decided according to the House of Lords by arbitration. So I fully understand the point that my Lord Justice Snowden's putting to me, but I'm trying not to make any assumptions one way or another. I hope that's a fair way of doing it, but I do understand. That's why I put or purported to make.
Well, you see, I understand make is clear, but purport to make an agreement. We might purport to make a legally binding agreement, believing that we are, but the law subsequently tells us that we were mistaken.
Oh, well, in that, the House of Lords would say if there's an arbitration agreement, then that's good enough.
Right, but that is perhaps a different situation from a situation where we do not purport to make a legally binding agreement because we know we are not there yet.
Well,
but we agree what it will contain if, as my Lord says, we get there.
Yes, and that's precisely what the House of Lords... I'm sorry to be boring about this, but that's precisely what the House of Lords says you shouldn't do. I'd
be very surprised if the House of Lords tells people that they can't negotiate subject to contract.
Oh, no. They don't do that. Absolutely. If it had been subject to contract, the position would have been blindingly clear. It wouldn't, however, be blindingly clear that the parties had agreed to refer to arbitration whether that subject was or wasn't lifted.
So is this a special rule for shipping contracts?
No.
Or a special rule for contracts
for arbitration.
arbitration? So subject doesn't mean subject to contract where you've got an arbitration clause.
No, it doesn't qualify the parties' agreement to arbitrate disputes about the relationship caused.
So is your submission that you can never, as soon as you mention an arbitration clause or agree that if a contract comes into existence, it will have an arbitration clause, that takes immediate binding legal effect?
No, absolutely not. I'm not. I'm taking your grammatical formulation, my lord, when I answer that question. No is my answer to the question that you have posed me. I hope I can explain my thinking.
I've probably said enough to at least to illustrate what I'm going to need some help with.
My lord, I always find it helpful as an advocate to know what is bothering the tribunal rather than, as one encounters with commodity associations, you've got no idea what they're thinking, if they're thinking anything at all. I find what your lordship has asked me extremely helpful.
Anyway, that's your first proposition. We've got the other four, I suppose.
Yes. The second proposition is if that presumption, the presumption that all disputes arising out from their relationship, is to be displaced, it can be only by very clear language or circumstances which directly relate to and impeach the validity of the arbitration agreement, or the arbitration clause, to give it a... There's a presumption which can only be discharged if there's very clear language that an arbitration agreement is to apply for the determination of such things as to whether there is or is not a valid binding contract. The third proposition is that there is no reason why the invalidity or even non-existence of the purported, brackets, main agreement should necessarily entail the invalidity of the arbitration agreement clause within it. There should be clear and powerful reasons for that result. I hope those last two submissions may assist in answering my Lord Justice Snowden's question. But I will develop it. The fourth proposition is that there may, however, be cases where, on their special facts or their special language, the main arbitration, the main agreement, and the arbitration agreement may indeed sink or swim together. But there should be powerful and clear reasons for that result, and it should not be presumed that that result should follow. I give examples as complete non-agreement or an absence of authority to bind as opposed to perhaps an excessive authority. And the last submission is the function of the courts is to support arbitration agreements and not to undermine them. If arbitral tribunals make an error of law in their determination of the validity of the main agreement, the proper course is an appeal under section 69 with its filter of leave, not a jurisdiction challenge under section 67, which has no filter. Now, my lord, those are the propositions which I advance. There's basically a presumption which has to require clear language or circumstances to rebut it. That is not an approach which Mr. Justice Jacobs took. I'm now going to try and establish why that is the law by reference to the authorities and the statute. As a brief history, I'm sure this will be very, very familiar to my Lord Justice Mayles, there was once a time when it was thought that matrix contracts and arbitration agreements within them were entirely coincident. That's the point, in a sense, made by my Lord Justice Snowden. But the demolition of that approach began in the 1940s with Hayman and Darwin's, which established what became known as the separability doctrine, whereby arbitration clauses and matrix contracts have separate and distinct existences, and an arbitration agreement is a collateral agreement. My lords, in the bundle of authorities, you've got a Hayman and Darwin's. It's at tab 2. It's a sufficiently famous case and it's not central, so I'm not. If you'd like to see it, I will show it to you, but it's...
No, take your own course, that's fine.
Well, I'll take my own course by not showing it to you at the moment. I would fully accept that arbitration agreements and matrix contracts are not entirely hermetically sealed from one another. Thus, for example, unless there is sound contrary reason, the proper law of a matrix contract is most likely to be the proper law of the arbitration agreement within it. That was decided by the Supreme Court in the Enco case, and I have no problem with that. But, in general, they are regarded as separate agreements pursuant to the separability doctrine. Now, it was developed somewhat by the Court of Appeal in Harbour and Cancer. If I can briefly take you to that decision, it's in the main bundle of authorities at tab 3. It was a case about a reinsurance which was allegedly void for illegality, for a breach of the Insurance Companies Act. And there was the defendants to the claim on the reinsurance sought a stay under what was then Section 1 of the Arbitration Act, is now Section 9 of the present Arbitration Act. And the judge below, Mr. Justice Steyn, as he then was, held that the issue of initial illegality was not within the jurisdiction of the arbitrator. He did not like that conclusion, but he felt obliged by a decision of the Court of Appeal in David Taylor and Barnett Trading to achieve it. On appeal, the Court of Appeal disagreed, and they held that even if the matrix contract, the main reinsurance in that case, was void for illegality, the question of whether it was void for illegality should be decided in arbitration with any issues of law resulting being the subject of section 69. Well, what was not then section 69 was then the appeals under the 1979 Act. And the head note, which has been marked, but I won't ask your lordships to read it particularly. The judgment of Lord Justice Leggett is probably most. There are markings up, which I think I can take you to 716, page 67 of the bundle. The arbitration agreement at the bottom of the page, if sufficiently widely drawn, is from its nature intended by the parties to govern any dispute that may arise between them, including a dispute about the initial illegality of the contract. There is no reason why the parties should have intended to exempt from the scope of the arbitration clause a dispute such as the plaintiffs saw fit to instigate here about whether the retrocession agreement was itself infected by illegality of the underlying insurance agreements. Otherwise, it would put it in the power of one contracting party to prevent arbitration from taking place simply by alleging that the contract was void for initial illegality, though why in this case the plaintiff should wish for more publicity remains a mystery. So you can see the, as it were, the policy reason why Lord Justice Leggett took the view that he did, and his conclusion at 719, page 70 of the bundle, is at C. In my judgment, this court is not obliged by authority to prevent the arbitrator from determining the issue of initial illegality. The tide is flowing in favour of permitting the arbitrator to do so, and it is no more necessary on grounds of public policy for the courts to retain exclusive control over the determination of the initial legality of agreements than over their subsequent legality. In particular, it would ill become the courts of this country, by setting their face against this jurisdiction, to deprive those engaged in international commerce of the opportunity of entrusting such disputes to English commercial arbitrators without the need for arbitration clauses containing elaborate self-fulfilling formulae. So you can see that Lord Justice Leggett was of the strong view that the voidness of the underlying agreement should not infect the parties' agreement to arbitrate. And then
quite so, although he is at some pains to point out that there is no dispute about the making, in fact, of the agreement.
I say there's no dispute about the parties making, in fact, a fixture containing the terms, which included the arbitration clause. So it may be that one is counting the number of angels dancing on the head of a pin, but I said it was undoubtedly the case that the parties agreed the terms of their fixture. I hope that's putting it entirely fairly. The question is, what did their fixture entail? But that they agreed terms is not in dispute. I know your lordship picked me up on that, and it is a very important point, as I think has been identified by my Lord Justice Snowden in the question that he asked me. But that the parties agreed a term which said arbitration, and I'm going to show you also what they agreed in terms of the Charterer's own standard terms. And then we have a slightly longer passage in the judgment of Lord Justice Hoffman, as he then was. It begins at page 722, where he sets out the background. And he says that the arbitration clause is collateral or separable. And then at page 723, referring to a submission of Mr. Longmore, as he then was, which is set out at F, he submits that the separability doctrine cannot apply to any rule which prevents the contract from coming into existence or makes it void ab initio. In particular, it doesn't apply to a statute or other rule of law which makes the contract void for illegality. It seems to me impossible to accept so sweeping a proposition. There will obviously be cases in which a claim that no contract came into existence necessarily entails the denial that there was any agreement to arbitrate. Cases of non est factum, or denial that there was a concluded agreement, or mistake as to the identity of the other contracting party, suggest themselves as examples. And that, in a sense, is the point that I think, at root, my Lord Justice Snowden's question was directed towards. And I do not in any way seek to depart from that. There may very well be such cases. But then it is interesting that Lord Justice Hoffman identified those specific examples rather than the more generic case that was put to me by my Lord Justice Snowden of saying, well, if parties have an if we can agree terms of a contract, then there will be an arbitration clause. That's a different issue. A curious contrary example says, he goes on, but there is no reason why every case of initial invalidity should have this consequence. A curious contrary example, decision of the Court of Appeal of Bermuda, in which the signatory to an agreement, well, I don't think possibly I need to tell this. We go over to the following page. He says, in every case, it seems to me that the logical question is not whether the issue goes to the validity of the contract, but whether it goes to the validity of the arbitration clause. And that is the first occasion when Lord Hoffman, as he then wasn't, addresses that particular issue. The one may entail the other, but as we have seen, it may not. When it comes to voidness for illegality, it is particularly necessary to have regard to the purpose and policy. I don't think that necessarily follows about illegality. And then at D, in deciding whether or not the rule of illegality also strikes down the arbitration clause, it's necessary to bear in mind the powerful commercial reason for upholding arbitration clauses, unless it is clear that this would offend the policy of the illegality rule. There are, first, the desirability of giving effect to the right of parties to choose a tribunal to resolve their disputes, and secondly, the practical advantages of one-stop adjudication, or in other words, the inconvenience of having one issue resolved by the court and then contingently on the outcome of that decision, further issues decided by the arbitrator. And I do hope that that paragraph, supplemented as it is by the speech of Lord Hoffman in the House of Lords, should give your lordships great cause to support the propositions 1 and 2, which I advanced to your lordship.
But what Lord Justice Hoffman is saying there is, look at the policy of whatever it is which invalidates the main agreement. Does it necessarily invalidate the arbitration clause in the main agreement? There being no doubt that the parties thought they were intended to enter into a valid agreement. He's saying, look at the policy of the provision that invalidates the contract, and he says it has nothing to do with invalidating an arbitration provision. But he contrasts that to a situation where the parties are not ad idem, where there is no consensus, where they have simply not consummated a legally binding agreement at all, didn't think that they were.
And the question is, you say consummated a legally binding agreement. If they have consummated a fixture and there is a dispute about whether it has the character
Can we not use the word fixture? Because I know you're resorting to broker speak, but can we actually use legal concepts?
I will use a legal concept.
For the non-shipping lawyer, as I am.
I hope I'll be forgiven that the term fixture has a certain ring to the shipping lawyer. I mean, Lord Justice Mayles will put me right upon that, but it's...
Well, I think for analysis purposes, it would be helpful to follow what Lord Justice
I'm going to. Yes, I'm going to. Possibly I was just apologising for my use of the term fixture to try to escape from the analytic confines that your lordship is...
Well, as long as it's not being used to paper over a crack.
No. it's where they make when they set out agreed terms between them, and all that is left is a determination of the legal character of those terms because of one of the terms of the contract. Then they have made an agreement. Whether they have made a contract is a different thing. They've made an agreement. Is the agreement a legally binding agreement?
Right.
Yeah. I'm sorry to.
No. I mean, I understand that loosely they say we have fixed the main terms to mean we have agreed what the terms of the contract when legally binding will be. That's one analysis. I don't think you're saying that when they say we have fixed the main terms, that they have entered into a legally binding contract on those main terms, if there is still a condition to be satisfied.
If I may say, my lord, and please don't take this amiss, main terms is, as my Lord Justice Mayles will know, is a somewhat pregnant phrase.
Well, I'm only using the pregnant phrase then that was used in the first paragraph
yes.
of the recap.
And I'll show you what they actually did was agreed all the terms, and I'll show you why they did that. But it's if your lordship asks me in a generic sense if they agree the main terms, if it's just an agreement between brokers or between parties operating through brokers on main terms, there is not then a contract in existence. Main terms require the agreement also of details. The very common way of placing a qualification on the legally binding character of the agreement that they've made is to say subject details. So when your lordship uses the term main terms, it is pregnant and it is.
Well, you're saying the brokers misused it in this case.
Yes, I do, and I'll show you why. Because actually they agreed each and every term because of, among other things, the incorporated terms. But I will show your lordship those terms. But the point that was made by my Lord Justice Snowden in relation to the judgment of Lord Justice Hoffman was that he was dealing with an undoubted agreement which was void for illegality, notionally. The parties had made an agreement, but it wasn't a contract because it was void.
But he said that the arbitration provision in it was not rendered void because it didn't offend the policy of the statute which imposed the invalidity. And he contrasted that with a situation where the parties just never reached, as he put it at 725, just above E, never reached consensus ad idem.
Yes, no, I hope I've said that I fully accept that. But where the parties reach a consensus ad idem on the terms, and the only question is whether those terms are the terms of a legally enforceable contract or of an agreement with a condition precedent yet to be fulfilled, then I would suggest that the correct tribunal to determine whether the condition precedent has been fulfilled is the tribunal chosen by the parties. I hope that's that makes sense. Of course, I fully accept the premise that your lordship gives me as to what was the background of that case. But I'll show you that the way that the Lord Hoffman in the House of Lords expressed it was rather wider. But the next point I should take you to is Section 7 of the Arbitration Act, which is in tab 11 of the bundle. Because I hope that this will guide your lordships on the very question that my Lord Justice Snowden was putting to you. For some reason, there seem to be two bits of the Arbitration Act, but it's Section 7 that I'm interested in tab 11. It's headed Separability of Arbitration Agreement. Unless otherwise agreed by the parties, an arbitration agreement which forms or was intended to form part of another agreement, whether or not in writing, shall not be regarded as invalid, non-existent, or ineffective, because that other agreement is invalid or did not come into existence or has become ineffective, and it shall, for that purpose, be treated as a distinct agreement. Now, the words or did not come into existence, I would respectfully suggest put my Lord Justice Snowden's question into context. The statute contemplates the non-existence of the matrix agreement.
Mr. Young, if that's what it means, doesn't that mean you were wrong to make the concession about subject to contract? Because this would apply just as much in a subject to contract case in the way you've just described it.
Well, if I was wrong to concede it, if I was wrong, then I suppose.
Well, I don't understand the distinction is maybe another way of putting my question to you.
And so what? And to follow up my lord, well, to follow up my lord's point, which followed up my question, I think.
Yes.
I mean, how do I read section 6.1 then? The definition of an arbitration agreement. It means an agreement to submit to arbitration present or future disputes,
whether they are contractual or not.
Yeah, well,
That's
whether
the disputes.
Whether they are disputes. But so, how do I read the word agreement where it appears in the second time the word agreement appears in the first line of paragraph?
Well, it is simply, well, in fact.
So could it mean in this part an arbitration agreement means a non-existent agreement to submit to arbitration?
It does not mean a non-existent agreement. There must be an agreement. Although, strangely, as my Lord Justice Mayles will know from his experience in the prestige cases, Section 82 of the Arbitration Act describes a situation where there may not be an actual arbitration agreement, but one is deemed to exist. We haven't got Section 82 here. So, but the prestige, as my Lord Justice Mayles will remember, was a case where there was no arbitration agreement, and yet there was an obligation as found by the arbitrator and the courts.
I'm not sure you can count on my memory, but it may not matter. But
well,
in Section 6, does agreement, when it says means an agreement, is that something different from a contract?
It's where they have agreed to arbitrate disputes.
But is that something different from a contract?
I think it is coincident with a contract, but it's
So is that a yes? I'm just struggling.
Well,
with that
once again, it is a legally enforceable agreement.
Right. So I can write the words legally enforceable into the.
You
first
can,
line.
my lord. Yes.
Legally binding.
Yes, I've got yes, absolutely. Yes, but whether it is legally binding is not dependent upon whether the contract, or rather the agreement, the terms in which it is found is itself legally binding.
Yes.
So Section 7 made the position, in my respectful submission, clear that if parties agree to arbitrate disputes, then they should arbitrate those disputes, even if they go to the very existence of the contract in which the arbitration agreement, the arbitration clause, is to be found. Everything is to go before one tribunal. All disputes, including disputes as to the validity or otherwise of the matrix contract. And that's why you can have an arbitration clause which contains a legally binding obligation to arbitrate, which finds itself in the middle of an apparent contract, which isn't a contract. And that's why, in my third proposition, I said there's got to be clear reasons in language or circumstances which show that the qualification to the main contract is material to the agreement to arbitrate.
So is the question then whether the parties have agreed a legally binding agreement to arbitrate in the recap message? If they have, then the arbitrator has jurisdiction. If they haven't, then he hasn't. And whether they have or not depends on the effect of the subject.
No.
No. All right. Well, all right. What I was putting seems to step up at the last
all right.
hurdle.
One of the questions is as to the effect of the subject, whether the subject contains clear language which relates directly to and impeaches the arbitration agreement, rather than relating to the matrix agreement.
And that use of the expression impeaches comes from Mr. Justice Steyn in the first instance in Harbour Assurance, does it?
Well, it also stated by Mr. Justice Gross in a case where he set out his provisional view, but I always found that provisional views of Mr. Justice Gross and Lord Justice Gross were persuasive. But impeaches is not necessary. It's what you've got to find is the reason why the matrix contract is, for some reason, not a contract at all. Does that reason go directly to the agreement to arbitrate?
The impeaches is picked up in the House of Lords in Fiona Trust.
Yes, yes, but it was my lord asked me if it came from Mr. Justice Steyn, and I couldn't remember Mr. Justice Steyn doing it, but certainly I think.
Well, he did, because if you look at the bottom of page 708 of the Harbour Assurance, the summary of his holding uses precisely that language.
No, I'm grateful, my lord. Yes.
Well, unless Lord Justice Ralph Gibson has just written it in himself.
Yes, I think your lordship referred to Lord Justice Steyn in Harbour Assurance. He was at first instance.
Yes.
Yes.
If you look at the bottom of 708 and the top of 709,
yes,
the summary of his judgment.
Yes. We've got the first instance judgment of Mr. Justice Steyn, I think, in my learned friend's supplementary bundle at tab 4. But yes, the reason in language and circumstances why the main contract is somehow not a contract at all must relate to, specifically to, the agreement to arbitrate embodied within it. But we finally get to Fiona Trust, which is at tab 4. Now, that was a case, once again, if I may summarise it, where a number of ex-Soviet companies had apparently, purportedly entered into charters on the Shell Time 4 form. And the issue was whether there was bribery which induced the decision of the owners to conclude the, for want of a better word, the fixture, and to conclude the arbitration agreement. Whether the bribery infected both contracts. And it's worth noting that the Shell Time 4 form, it's actually not quite accurately described in the headnote. It appears at page 82 of the bundle 955 of the report. It's an arbitration clause, which is at the very bottom of the page. It's an arbitration clause which starts life as a jurisdiction clause with an option in either party to elect for arbitration if it wishes. and that option then becomes a binding on so as to turn it into an arbitration clause. Now, at page 83 of the bundle, 956 of the report, at paragraph 5, the issue which Lord Hoffman is dealing with is as to the effect of bribery on inducing both contracts. Both of these defences raise the same fundamental question about the attitude of the courts to arbitration. Arbitration is consensual. It depends upon the intention of the parties as expressed in their agreement. And that, I see my Lord will get the Snowden point there. Only the agreement can tell you what kind of disputes they intended to submit to arbitration. But the meaning which parties intended to express by the words which they used will be affected by the commercial background and the reader's understanding of the purpose for which the agreement was made. Businessmen, in particular, are assumed to have entered into agreements to achieve some rational commercial purpose, and an understanding of this purpose will influence the way in which one interprets their language. In approaching the question of construction, it is therefore necessary to inquire into the purpose of the arbitration clause. As to this, I think there can be no doubt. The parties have entered into a relationship, an agreement, or what is alleged to be an agreement, or what appears on its face to be an agreement, which may give rise to disputes. They want those disputes decided by a tribunal which they have chosen, commonly on the grounds of such matters as its neutrality, expertise, and privacy, the availability of legal services at the seat of arbitration, and the unobtrusive efficiency of its supervisory law. Particularly in the case of international contracts, they want a quick and efficient adjudication and do not want to take the risks of delay in too many cases, partiality in proceedings before a national jurisdiction. Over the page, if one accepts that this is the purpose of an arbitration clause, its construction must be influenced by whether the parties, as rational businessmen, were likely to have intended that only some of the questions arising out of their relationship were to be submitted to arbitration, and others were to be decided by national courts. You'll see how I've stressed when giving the proposition that the relationship, it makes no assumptions. But I do suggest that the criterion of a rational businessman requiring only some questions arising out of the relationship has been established as wrong. Could they have intended, he continues, could they have intended that the question of whether the contract was repudiated should be decided by arbitration, but the question of whether it was induced by misrepresentation should be decided by a court? If, as appears to be generally accepted, there is no rational basis upon which businessmen would be likely to wish to have their questions as to the validity of the enforceability of the contract decided by one tribunal and questions about its performance decided by another, one would need to find very clear language before deciding that they must have had such an intention. A proper approach to construction, therefore, requires the court to give effect, so far as the language is used by the parties will permit, to the commercial purpose of the arbitration clause. But the same policy of giving effect to the commercial purpose also drives the approach of the courts and the legislature to the second question raised in this appeal, namely whether there is any conceptual reason why parties who have agreed to submit the question of the validity of the contract to arbitration should not be allowed to do so. And then he refers to section 7 of the Act, and then continues at paragraph 10. This section shows a recognition by Parliament that, for the reasons I have given in discussing the approach to construction, businessmen frequently do want the question of whether the contract was valid or came into existence or has become ineffective, submitted to arbitration, and that law should not place conceptual obstacles in their way. And then he discusses some of the history, which he regards as a history which doesn't reflect very well on English law, as to refined analyses of particular forms of arbitration clause, whether it's an arbitration clause arising, disputes arising under a contract or out of a contract or in relation to a contract. He said all of them should really be all of those cases should be put to one side, and one have a new approach, and that's paragraph 12, where he makes this claim. He says, I don't propose to analyse these and other such cases any further, because in my opinion, the distinction which they make reflect no credit upon English commercial law. It may be a great disappointment to the judges who explained so carefully the effect, blah, 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 blah. And then 3 lines down, so I applaud the opinion expressed by Lord Justice Longmore in the Court of Appeal at paragraph 17, that the time has come to draw a line under the authorities to date and make a fresh start. I think that a fresh start is justified by the developments which have occurred in the branch of law in recent years, and in particular by the adoption of the principle of separability by Parliament in section 7 of the Act. That section was obviously intended to enable the courts to give effect to the reasonable commercial expectations of the parties about questions which they intended to be decided by arbitration. But section 7 will not achieve its purpose if the courts adopt an approach to construction which is likely in many cases to defeat those expectations. The approach to construction needs to be re-examined. In my opinion, the construction of an arbitration clause should start from the assumption that the parties, as rational businessmen, are likely to have intended any dispute arising out of the relationship into which they have entered or purported to enter to be decided by the same tribunal. The clause should be construed in accordance with this presumption unless the language makes it clear that certain questions were intended to be excluded from the arbitrator's jurisdiction. As Lord Justice Longmore remarked at 17, if any businessman did want to exclude disputes about the validity of a contract, it would be comparatively easy to say so.
How far do you want us to read? There's quite a lot of sidelining here.
Yes. Well, yes.
Well, I mean, you've just read virtually the entirety of Lord Hoffman's analysis, but on a point which doesn't arise in our current case.
Well, it does.
Well, it doesn't, because you've just read Lord Hoffman's analysis on the approach to construction of the arbitration clause.
Yes.
I mean, that's not the question in our current case, is it?
Yes, it is.
Well, sorry, you haven't even shown us the arbitration clause. If you're asking us to construe it, it's not even in the judgment.
My lord, that's why I set out how I was following the route map. I was going to show you the principles first, and then show you...
These are principles relating to how you construe an arbitration clause. The second question that Lord Hoffman addresses, I thought, is the relevant one in our case, which is what happens when you have an invalidity or some other attack on the matrix contract. Does that affect the arbitration clause, which is the second question, which he starts dealing with at paragraph 16.
Indeed.
But what you've read to us, I have no problem with what you've read to us so far, but I don't see that it's the relevant
it is the relevant question
in the current case.
My lord, it is the relevant question because what you have to do is to construe the agreement to arbitrate.
Well, you haven't even shown us the arbitration.
Well, no, as I said, I'm showing you the principles first, and then I'm going to show you the agreement to arbitrate. I've done it in that way so that...
But I'm not sure the judge approached this case as a case of construction of an arbitration clause, did he?
Well, what he should have done... I'm clearly in error in not showing you the arbitration clause first, but I submitted that it was important that your lordships have in mind the proper approach to the construction of what you're going to look at first. But I'm obviously in error, and I will show your lordships the clause, well, the agreement.
I didn't even think there was any doubt about it. I mean, it's not even, the clause isn't even recited in the judgment, is it?
Well, yes, it is.
Well, he just summarises what it
yes.
says, but he doesn't actually refer to it. I didn't think there was a dispute about how to construe it.
May I just finish what the Fiona Trust, because that is, in a sense, I suggest, is the origin for the proposition that there should be a presumption that an arbitration agreement should apply to all disputes relating to the relationship created or purported.
Well, as I read Fiona Trust, there is a presumption when construing what is an arbitration clause that it should apply to various things, but that's as a matter of construction of the wording of the clause, which is why Lord Hoffman starts as he does in paragraph 5, having just identified, just at the end of paragraph 4, the two questions. The first is as a matter of construction, and then the second is that the jurisdiction and arbitration clause is liable to be rescinded and not binding.
And
that's the question.
reason I'm going to show your lordship, I will show your lordships, is whether the subject shipper's approval of the vessel had any relationship at all to the agreement of the parties, not a third party, to arbitrate disputes arising out of the parties' relationship. And I'm going to say, properly approaching the construction of that the subject does not impede the effectiveness of the arbitration agreement and does not take outside the jurisdiction of the arbitrators the determination of the question of the effect of the subject on the main charter fixture agreement. So with respect, my lord, you've got to construe, and I will show it, I will show you, you've got to look at the subject and say, given the presumption that we have to apply when parties have agreed arbitration, does this subject relate to the arbitration agreement? And very clear language is required to make it relate to the arbitration agreement so as to exclude the jurisdiction of the arbitrators from deciding an issue as to the existence of the underlying matrix contract. So it is a question of construction, but not just of the arbitration clause. It's the arbitration clause together with the subject. You have to construe the whole and say, is the subject such as to preclude the effectiveness of the arbitration agreement and the jurisdiction of the arbitrator to decide whether the subject did have that effect on the main contract. So I'm now frustrated with myself for not having started with the showing you the agreement, but I did want to show you the authorities which establish that there should be a presumption that where parties agree arbitration, it should apply in the absence of very clear language. And I've added in my own proposition all circumstances. For example, no agreement at all, or no authority at all. But the principle is you've got to presume that all disputes arising out of the relationship are referred to arbitration, and then applying that presumption, ask yourself, is there clear language to show that that should not be the case? Those are the two guiding propositions from Fiona Trust. And one sees that, going over to para 17, I appreciate that I'm reading significant tracts, but it is really rather important that your lordship has in mind what they say. Lord Hoffman continues at 17.
If you want us to read paragraphs, is it quicker if
yes,
you simply tell us what you want us to read?
Yes.
Can do that?
Well, the passages that are highlighted, my lord.
Yes.
Yes, I think they've all been highlighted.
Yes.
Perhaps I might do that on another occasion. Your lordship has the propositions which I derive, or I purport to derive from the speeches, and you can see whether those passages do or do not support those propositions.
Yes.
But perhaps would that be?
Yes.
Is that an acceptable way of proceeding, my lord?
Yes, that's fine.
I'm anxious not to take up time unnecessarily with a tedious reading. I mentioned the judgment of Mr. Justice Gross in the UR Power case, which is at tab 5. it's a passage in at page 503, which Mr. Justice Eder then was.
Sorry, are we moving away from Fiona Trust
Well,
now?
I'm,
Well, because sorry,
Yeah.
just to be fair, I mean, if we are, I mean, I thought, perhaps naively, that the relevant passages from Lord Hoffman's judgment were probably paragraphs 16 through to 19,
as to which your lordship's right.
and at the end of paragraph 18, there is a sideline passage which I thought would probably be relied upon you and probably needed to be examined a little more closely. I mean, am I wrong in that?
No, you're not wrong in that.
Right.
I was going to read them out to you and do that, but I was.
Well, you don't need to read them, but
Well,
at
Take,
least
take,
I'd
take
quite
them
like
as
to.
read and make any submission on them you want
Yes,
to make.
I mean it's the passage that my Lord Justice Snowden has identified at 18 is precisely it. If the arbitration clause that has been agreed, and it has been agreed, the parties will be presumed to have intended the question of whether there was a concluded main agreement to be decided by arbitration, and it requires very clear language. And at the bottom of the page, Section 7, in my opinion, means that they must be treated as having been separately concluded, and the arbitration agreement can be invalidated only on a ground which relates to the arbitration agreement and is not merely a consequence of the invalidity of the main agreement. But I've given you the propositions that I derive. I'm anxious not to delay your lordships with religious reading out of tracts from the judgment, but at the same time, in my submission, the two principal propositions are: there is a presumption when parties agree arbitration, then all disputes should be referred to arbitration and not carved up into several different tribunals. And secondly, you require very clear language for circumstances, and I keep adding the circumstances where, for example, there has simply been no agreement at all for anything. And I submit these sideline passages, and particularly the passage at the bottoms of paragraph 18 and 19, as identified by my Lord Justice Snowden, are critical. And one sees the Lord Hope, with whom all of their lordships agreed with Lord Hoffman. Lord Hope agreed with Lord Hoffman, and Lord Brown agreed with both Lord Hoffman and Lord Hope. But the Lord Hope at paragraph 27, there's no sign here that, leaving aside the question of arbitration for a moment, that the parties intended that the disputes which were to be determined in accordance with the laws of England be decided by the English courts were not to include disputes about the Charter's validity. The simplicity of the wording is a plain indication to the contrary. And then at a couple of lines further down, taken overall, the wording indicates the arbitration to be chosen as a one-stop method of adjudication. And at the bottom of the page, the purpose of the clause is to provide for the determination of disputes of all kinds, whether or not they were foreseen at the time of the contract. And at C, one should be slow to attribute to reasonable parties an intention that there should, in any foreseeable eventuality, be two sets of proceedings. And then his lordship then referred to the US.
Again, he's dealing with the issue of construction there, isn't he?
Which is one of the issues that you have to deal with as well, my lord. And it's really, and then we go to paragraph 85 at page 90 of the bundle 963 of the report. He's dealing with an argument that there was no contract to go to arbitration at all. The arbitrator's award can have no validity. That's not this case, however, and this may be relevant to my lord. The appellant's argument was not that there was no contract at all, but that they were entitled to rescind the contract, and I accept, including the arbitration agreement, because the contract was induced by bribery. Allegations of this kind, if sound, may affect the validity of the main contract, but they do not undermine the validity of the arbitration agreement as a dispute agreement. The doctrine of separability requires direct impeachment of the arbitration agreement before it can be set aside. This is an exacting test, and that's the exacting test that the learned judge ought to have applied, and I'm inviting your lordships to apply.
Now, impeachment arises where there is an agreement to
Yes.
arbitrate, and the question is whether the invalidity affecting the main contract also impeaches the arbitration clause.
That's exactly our case.
Well, the case against you is that that is not the case. The case against you is that this is paragraph 34 territory, where there is no contract to go to arbitration at all.
Yes.
That's the issue, isn't
That's
it?
the issue.
Was there an agreement to arbitrate?
And the question
which
you
means a contract to arbitrate.
Yes, and the question which you have to ask, my lords, is whether the subject to the approval by a third party to the vessel in any way related to the agreement to arbitrate expressed in the fixture recap and directly impeached it, to adopt Lord Hope's words. And that's the question which you've got to ask. Was the approval of the vessel a qualification to the parties' agreement to arbitrate disputes, including whether that subject was or wasn't lifted?
So that's a question of construction of the subject too,
Yes.
not a question of construction of the arbitration agreement. So you were right not to bother showing us it in the first instance.
Well, I'm glad that you think I was right not to. I hope.
Sorry, there was a question mark at the end. There was a question
comfort.
mark.
I'm taking such comfort as I may derive. It's a question of construction of what the parties agreed, and they certainly did agree the terms of the recap. The question is, what is its legal character, and in particular the legal character of the arbitration clause in the light of the principles derived from Fiona Trust, that you should assume that they intended all disputes, including disputes about the existence of the main agreement, to be referred to arbitration, unless there's clear language. And you have to ask yourself, is the subject of a third party's approval of a vessel clear language relating to and impeaching the arbitration agreement? And to which I say it's got absolutely nothing.
So subject to contract would mean there was no contract to arbitrate. Subject to board approval would mean there was no contract to arbitrate. But you say, and this is the issue, subject to shipper's approval is different.
I say subject to shipper's approval is certainly different from the two that you have indicated, my lord. I'm not subject to board approval or subject to contract may or may not be. That's not the issue before your lordships. I would accept that in some cases subject to contract may be such as to go to the applicability and validity and effectiveness of the arbitration agreement, but you're not confronted with that. You have to ask yourself, does the approval of the vessel by a third party somehow relate to the agreement of the parties to the charter fixture to arbitrate their disputes? That's the question you've got to ask. Starting with the presumption that clear language is needed to suggest that there should be a division of dispute resolution tribunals.
Right.
Now, Mr. Justice Gross, in UR Power, that was a case involving phosphor arbitration, once again the passage is highlighted at page 100, page 503 of the report, and I won't read it to your lordships because it was only a provisional view, albeit a provisional view of Mr. Justice Gross, as he then was. But he regarded the thrust of his provisional view was rather more in my favour than not. The only actual case against me, if it's against me at all, is the judgment of Mr. Justice Eder, a first instance, in the Pacific Champ, which is at tab 8. Now, that was a case somewhat dependent upon its facts, but does actually raise the point that my Lord Justice Mayles questioned. That was a case where there was a recap. What the parties agreed wasn't a binding recap, and it had, if you see at the left-hand side of the head note, you'll see 4 numbered paragraphs, 10, 11, or clauses, 10, 11, 12, and 13. English law and arbitration to apply, hold condition clause as per head charter party, sub-review owners head charter party, back to back, ETB, and subject charterers reconfirmation, close of business, New York time, February the 12th. That subsequently got moved to February the 13th on the top of the next column. Then the learned judge considered the evidence, because it was a Section 67 application. He considered the evidence afresh and concluded that there simply was no agreement at all. And that was, in a sense, all that he needed to decide. But he did consider the question of the effect of the subjects of board approval and charterers confirmation at paragraph 35, which is at page 327 of the report. And this is, I think, the ironically the sidelining is on the wrong side of the page. It really should be on the facing page. Mr. Justice Eder gives 4 reasons for concluding that the arbitration agreement was not concluded. And he says he accepts the submissions from Mr. MacDonald Eggers, Queen's Counsel, and he says, A, item 10 of the second recap, which makes the provision for arbitration, is like all the other terms of the recap, at the very least, conditional upon 2 subjects contained in items 12 and 13. Accordingly, if item 12 was not satisfied, as HMM currently contends, there can, in my judgment, be no operative arbitration agreement. And that's the point, I think, that's been made by my Lord Justice Snowden. So he says he concluded that on the true construction of the fixture recap, the agreement to arbitrate was itself conditional upon the acceptance, the board approval, and of the back-to-back charter. Then B, he concludes well, I don't think that actually matters, because it was an issue about which particular form of charter was incorporated. C, if there was no consensus at all in accordance with submissions 2, 3, and 4, and they are set out at page 325, the lack of consensus not only prevented any charter from coming into existence, but also any arbitration agreement from coming into existence. That's my Lord Justice Snowden's point. And he goes on, there is no evidence or other material in the particular circumstances of the present case that the parties intended here that any alleged arbitration agreement was intended to have an effect independently of the existence of the charter party. He didn't apply the presumption. In my judgment, the provisional view put forward by Mr. Justice Gross and UR Power is distinguishable. Indeed, Mr. Justice Gross made it clear that whether or not there's an arbitration agreement in existence will depend on the circumstances of the individual case, and observed that in the case before him, the question here went not to the existence of any consensus ad idem, like Mr. Justice Steele in another case, Pacific Interlink, which was also distinctly factual. And then D, as the alleged charter and the alleged arbitration agreement were on ABT's case contained in the same document, namely the second recap, the submissions advanced by HMM to the effect that there was no binding charter necessarily mean that there was no binding agreement. See Fiona Trust. Now, that's a slightly odd one, where if the arbitration agreement is in the same document, because we know that the arbitration agreement in Fiona Trust was also in the same document. But that, in the Pacific Champ, is the extent of Mr. Justice Eda's reasoning on the subjects. But he concluded that there was absolutely no agreement to anything on the facts, and he gave no leave to appeal. So that is a somewhat different factual case. My learned friend relies heavily upon the Leonidas, which is at tab 9, which is a judgment of Mr. Justice Foxton. And my learned friend will doubtless develop his submissions on this case. But in my submission, the Leonidas does not concern an arbitration agreement at all. So what is at the heart of the case before your lordships wasn't before Mr. Justice Foxton, because it was just a simple trial of whether there was a charter fixture that was concluded with subjects. So the critical point, the critical presumption, and looking for clear words, or clear language and circumstances, simply missing. So the Leonidas really doesn't enlighten anything very much at all. But if I could just make, I think...
Well, sorry, I'm at risk of going over old ground.
No.
You talk about presumption. The presumption you rely on is a presumption as to construction of an arbitration clause, whereas what Mr. Justice Foxton was dealing with, I thought, was the effect of subjects as a matter of interpretation, and I thought that is what we're dealing with here, isn't it?
We are here dealing with this particular subject, which I will be showing you in an instant, and its effect upon an arbitration agreement. So the answer to your lordship's question is no.
So are you saying that when the court is called upon to interpret something which is not an arbitration provision, which is a subject to provision, a subject provision, you adopt a different approach to interpretation of that provision because somewhere else there is an arbitration clause?
No, no, that's not what I'm saying.
No.
The question is, you've got to construe the fixture, and I hope you'll forgive me for calling it the fixture. Your lordships are there to construe the fixture, the expression of agreement of terms. One of those terms was an arbitration agreement, and I'll show you it was a very detailed one. The question is whether the subject which appears at the beginning of the fixture recap was a subject to the arbitration agreement or just a subject to the matrix fixture.
Yeah, so we're interpreting the scope or the meaning of the subject clause.
Well, you're interpreting
hence
the
why
meaning.
nobody has bothered about the actual terms of the arbitration clause.
That, my lord, that is absolutely right. Although the actual arbitration clause, which I'll show your lordship, has any dispute arising out of the contract. But we've been told by the House of Lords not to pay too much attention to the prepositional linkages.
Yep.
But you've got to construe the terms that have been agreed by the parties as to whether those terms, properly so construed, make the subject about the third party's agreement of the vessel referable to the arbitration. Does that prevent the arbitration agreement from coming into existence? So it's the whole shooting match. It's got to be construed. Okay. My lord, as I say...
So Mr. Justice Foxton, as I read this case, interprets subject to supplier's approval as a precondition, meaning that there is no contract about anything which follows until the subject is lifted. But you say but the position is different if one of the things which follows is an arbitration clause.
Yes.
That's
what the House of Lords said.
But that's yes. But I mean that is a correct analysis of what he decided in a case which didn't have an arbitration clause, or where there was no point taken about it if there was.
Well, it didn't have an arbitration clause. It went straight to court.
Yeah.
It's, as I say, what Mr. Justice Foxton did not do was begin with the presumption and then say, well, are there clear words? He didn't need to, because that's not what that's not the issue before him. If I may, as I'm sure my learned friend will.
Well, it's quite likely it did have an arbitration clause, isn't it? Because most fixtures
not all, no,
do. Not all, but most. It would have had either a.
Yeah.
Are we told?
It was a jurisdiction clause.
Was it?
Yeah.
Okay.
Your Lordship is right. Many charters do have arbitration clauses, and that, in a sense, is as your Lordship will know, many charter party agreements never get embodied into a charter party at all. They remain as a fixture recap.
It's the exception rather than the rule these days, as I understand it. Anyway, there we are.
Yes, it does happen, but for voyage charters, it's certainly the exception. For period time charters, it may not be. But I'm sorry to bash on about this, but I'm very keen that my Lord Justice Snowden should know that this is how business is done in the shipping world, and I'm sorry to forgive me from bashing on that, but this is almost certainly a contract that would never have been nicely typed up and signed ever. It would have remained as a fixture recap. But the 6 points, if I may make them briefly about the Leonidas, which doesn't relate to the central question, are first, that at paragraph 53, Mr. Justice Foxton rightly says that no, 52, I'm sorry. Each case will depend upon its own individual facts and commercial context. It is clear that a subject is more likely to be classified as a precondition rather than a performance condition if the fulfilment of the subject involves the exercise of a personal or commercial judgment by one of the putative contracting parties. And that was in a sense, what Mr. Justice Eder was concerned with. So the first point is each case will depend upon its own facts. Mr. Justice Foxton, was concerned with 4 subjects. So paragraph 12, and the head note is actually quite bad on this. So could I just ask you to look at paragraph 12 so that you can see the context in which the learned judge was considering the case. Paragraph 12, the transaction was subject to charterers, shippers, subject to STEM, and he says, it is common ground that S/S/R/MGT stood for STEM, suppliers, receivers, management, and that STEM is an acronym or subject to enough material, which meant subject to charterers confirming that they had sufficient cargo to load on the vessel. The result was that the conclusion of the charter party was subject to A, the availability of sufficient cargo, B, supplier's approval, C, the approval of the receivers of the cargo, and 4, the approval of trafigurers' management. Now, it is absolutely plain that the first subject to STEM, has been the subject of long-standing authority, saying that that is a condition precedent to a contract. That was a decision of Mr. Justice Rowland in KKK shipping, which I don't think we've got it, but I don't think you need to see it. And the last was the approval of trafigurers' management. That was accepted by Mr. Birss, who was then appearing, to be a condition precedent. That's at paragraph 49. So you've got 4 subjects all wrapped up in one bit of broker's acronym. The first and the last were accepted to be conditions precedent. So the question that had to be addressed by His Lordship, Mr. Justice Foxton, was, given that each case has to be seen in its own circumstances, the first and fourth were conditions precedent, but the second and third were not. And one may have some sympathy with the learned judge for concluding that they were probably all intended to have the same character. But there was nothing material showing that the second and third subjects were to have a different character from the first and fourth. The third point I wish to make is that there was no set of incorporated terms which gave qualifying colour to the agreed subjects. If you look at paragraph 61, Mr. Justice Foxton notes that other forms of contract do have, this is at page 177, do have qualifying terms about shippers, receivers' approval and about the approval of a vessel nomination. It's actually in a passage that's not highlighted, but he identifies just below the, on the left-hand column, just below the hole in the page, he identifies the Shell International Trading and Shipping terms and the BP International General Terms and Conditions, which both have provisions relating to vessel approval by suppliers and receivers. Now, the case before Mr. Justice Foxton did not have any such qualification. Ours did, as I will show you. And in a sense, the terms in the Shell terms and the BP terms were such that a vessel could be not approved, a nomination of a vessel could be not approved only on reasonable grounds. And that was precisely the agreement of the terms agreed in the present case. So what your lordships have to do, if I can address in a sense the point made by my Lord or Justice Snowden, is to construe a fixture, an agreement, containing a large number of agreed terms, including the charterer's own standard terms, which provided that vessel approval could only be on reasonable grounds. So what you've got to ask yourself is, did the parties to an agreement which contained that term agree that there could be an absolute refusal on unreasonable grounds by a shipper, which affected the arbitration agreement, or indeed whether the charterers could make any attempt to get any approval from the shipper, or indeed, having made an attempt and got approval, they could just be very quiet about it, not communicate it, and thus prevent the subject from being satisfied. So the question you've got to ask yourself is, looking at the contract as a whole, looking at the terms agreed as a whole, did these parties agree that the contract could be subject to an unreasonable refusal or an absolute refusal on the part of the would-be charterers to do anything with regard to getting or communicating the existence of shipper's approval?
I thought you said that's the question we mustn't ask ourselves.
Well, no,
Isn't that
you've
the
got
Section 69 question.
That's the Section 69 question, but that's the question which you've got to ask yourself: was that a subject to the arbitration agreement? It was there in that case, as paragraph 49, Mr. Justice Foxton's judgment. He made the proposition that he accepts the submission that an important factor in determining whether a subject is a precondition or a performance condition is whether the satisfaction of the subject depends upon the decision of a contracting party or that of a third party. And you've got to ask yourself that in the context of the arbitration clause, where you're looking for clear words to rebut the presumption. So, and I submit...
Well, clear words where?
Clear words in the terms agreed.
And the presumption is a presumption as to the scope of the arbitration agreement.
Correct. Yes. Yes.
As to the scope of the arbitration agreement.
Yes, as to whether the arbitrator can determine issues as to whether the subject was or was not lifted or not lifted, was or was not reasonably or unreasonably withheld, or whether it was itself a condition of the existence of the contract, the charter party. The charter party is a charter fixture. But Mr. Justice Foxton thought that if it was a matter for a third party, it was more likely to be a what he called a performance condition, not a condition precedent. Although in the event, in that case, he held that it involved elements of commercial evaluation by the charterers, so as to change its character from a performance condition as it would have been because it was the subject of a third party approval to a condition precedent.
Mr. Young, can I make sure I'm not missing something? As I've understood what Mr. Justice Foxton was doing there, the distinction he's drawing between a precondition and a performance condition is that if it's a performance condition, then there is a contract, and this is a term in it. It may or may not be satisfied, but there's definitely a legally binding contract between the parties. Whereas if it's a precondition, then there isn't a legally binding contract unless it's satisfied.
Absolutely right. Absolutely
That's
right.
the point.
Yes, I'm sorry if I'm using the shorthand derived from. No, what your lordship says is absolutely right.
Yeah.
So
if in this present case before us, the subject that's being considered is a performance condition, then we wouldn't be here at some level because there would be an agreement and there would be an arbitration agreement.
Absolutely right. And what Mr. Justice Jacobs has held, really asking himself the wrong question, is was it a performance condition or a precondition?
But if it's a precondition, then there isn't an agreement. That's the point.
Yes. But it wouldn't necessarily follow that the arbitration clause was not.
Well, that's your case.
By it. That's the point. But it's the point that your lordship makes is absolutely right, and it's if I may. In the context of charter fixtures, one very often has, or indeed international sale agreements, a subject of relevant import or export licenses. I'm sure my Lord Justice Mayles would be familiar with all of these cases. And the approach...
Actually, I've never seen that in the charter party, though.
No,
anyway,
well...
I'm sure you have.
I have actually, but I agree. It's more in the context of sale agreements, but certainly sale agreements. But the law is, the learning is, that such agreed terms require the person who has to get the relevant import license to make a reasonable attempt to get it, and if he doesn't make a reasonable attempt, to prove that even a reasonable attempt would have failed. I'm sure your lordship is very familiar. So it's those sorts of subjects have within it an obligation on the part of a contracting party to do something to try. Mr. Justice Foxton concluded that on the facts of his case, there was no obligation on the part of Trafigura as the charterer even to try to get suppliers or receivers' approval, which was his conclusion on the facts of that case. But the basic point that your lordship is putting to me is absolutely right.
Thank you.
But it doesn't follow that just because it's a condition precedent to the Charter, that it's a condition precedent to the arbitration agreement, which comes back to my central thesis. And here we have not only approval of a vessel by a third party, we've also got relevant factual elements of the recap. And finally, I'm going to get to the recap. It's, if I can, it's in bundle 2 at tab 2. And I do appreciate that I'm probably, the cart and the horse may be going in rather unusual order. But I hope your lordships will see that it's important to establish the criteria before actually looking at what you're actually required to look at. Page 9, we have the having confirmed, having agreed main terms. Although main terms is somewhat inapt in this case. Emboldened. It's undoubtedly emboldened. Whether that was an accident or not, I don't know. Sub-shipper receiver's approval within one working day after fixing main terms, and receipt of all required corrected certs/docs. And then there's a passage below it which perhaps is material. Rightship inspection will be conducted on 3rd September. Owners will provide required certs, latest, before vessel sailing, I think, intended 5th September. Owners will endeavour to provide all required certs, docs, earliest possible. Now, you're supposed to look at all of the terms agreed. The subject was as for approval within one working day, fixing main terms, and receipt of all required certs and docs. And the certs and docs related to the rightship inspection. Now, I'm sure my Lord Justice Males knows all about rightship, but for the benefit of my Lord Justice Birss and Lord Justice Snowden, if I can give a quite quick summary of what rightship is. It's a company that was established jointly by Rio Tinto, BHP and Cargill for ensuring the proper quality of shipping, lifting their cargoes out of predominantly Australia and South Africa. It looked at the physical condition of the vessel, but also the qualities of ship management and the like. It's not just an MOT. It's a rather sophisticated analysis of ship operation. But basically, you cannot load bulk cargoes out of Australia without getting rightship approval. Although technically rightship doesn't approve, rightship has a star system where for vessels under the age of 20 years, 3, 4 and 5 stars are generally regarded as acceptable, and 1 and 2 are generally regarded as not acceptable except in special circumstances. For older vessels, it's not quite like that. But rightship approval, in inverted commas, is a requirement for a vessel loading in Australia, as the Newcastle Express was, almost out of its own name, and indeed going to China. So the only thing that any shipper would really be interested in is when it gets onto the rightship website, what is the star rating? Now, because rightship looks at quality of management, when there is a transfer of ownership of a vessel, all previous rightship records are irrelevant, and rightship then has to inspect the vessel and its management afresh. And that's what had happened in this case, as was perfectly plain, because it was a vessel that had been originally called the China Steel Growth, and then to be renamed Newcastle Express. Therefore, in order to get rightship approval, or 3 or 4 or 5 star rating, there needed to be another inspection. And that inspection was due to be taking place on the 3rd of September. And the vessel was going to sail on the 5th of September. And the owners will endeavour to provide all required certificates earliest possible. So they were, whether they were undertaking a contractual obligation is another matter, I suppose, but they were agreeing to provide the certificates as soon as possible, among others the rightship approval, which would have affected, almost exclusively affected, the shipper's approval. So that's where you've got to look at the subject in the context of its entire content rather than ignoring the rightship. Now, the charter fixture was set out in very similar, very normal terms, setting out individual terms that are agreed, such as, for example, at page 10 of the bundle at the top, the full itinerary, estimated open Zushan, 5th of September, that's where the previous discharge port, ETA Newcastle, that's Newcastle, New South Wales, around the 21st of September. And then at the middle, of, just under the first hole of the page, gearless, rightship approved, classed highest Lloyd's 100A1 and so on. And then a passage my learned friend will rely upon, just below the second hole in the page, prior to charterers lifting subjects, owners to provide charterers with the speed and bunker consumption figures which will actually be used to prosecute the voyage under the fixture, i.e. ballast laden and working. So the owners undertook an obligation prior to lifting of subjects. Now, query what the nature of that obligation perhaps was. And then you go through the standing entirely traditional form of fixture recap, whose account it is, what the freight is, what the lay time is, what the demurrage is. And then we get at page 12, para 17. Contract law and arbitration forum, GA arbitration to be in London, English law to be applied, small claims procedure to apply for claims for $50,000 or less. Now, that doesn't make much sense until you actually see that at the bottom of item 20, it says charter party, otherwise as per attached charterers pro forma CP with logical alterations. Now, the charterers standard terms are at pages 14 and following, and I'm probably, because I'm becoming decrepit, my eyesight is sometimes in the court. Could I just ask your lordship's usher to, I've got a slightly enhanced version of the terms. I think I was brought up in the days when Lord Justice McGaw used to take you to task for not producing legible copies, and I think now in my eyesight being what it is, I had some sympathy with that.
I'll make them bigger on my computer, Mr. Young.
This is the advantage of an IP background. It's quite beyond me. The point is still the same. I can't read them; that too small. And we see the standard form charter party of the charterers, who are the people denying the existence of the arbitration agreement, and it has box 25 on the second page, law and arbitration clause. Please state place of arbitration if not filled in. 19A, Hong Kong English law to apply. That then makes sense when you go to clause 19 of the additional terms, which I've highlighted in pink And this is why I say, I think in answer to my Lord Justice Snowden, the arbitration clause is rather more specific and rather more detailed than just the recap.
Where is the place of arbitration to be?
London.
Not Hong Kong.
No, because they agreed specifically in the recap London arbitration.
See, the judge didn't actually even bother setting out clause 17 in the recap, still less clause 19 in this document. It formed no part of his reasoning, did it?
No, and it should have done. And I'll tell you why. Because the recap just says GAR London, small claims, small claims. Unless you actually know what that means, it doesn't fully enlighten you. They incorporated the terms of the charterer's standard form, which is this, clause 19, and then it makes sense. So what was, if you'd imagined the writing up of the execution of the charter party, box 25 would have had English law London arbitration. And then what we have at clause 19 of the charterer's standard terms, so this is, it's not my standard terms, it's Mr. Holroyd's client's standard terms. 19 is split into 4 subparagraphs. The first is, broadly speaking, Hong Kong arbitration. That's 19A. 19B is where if it's New York arbitration. C, any dispute arising out of this charter shall be referred to arbitration to the place indicated in box 5. The laws of the place indicated shall govern the charter party, and that's why London became relevant. And D, if box 25 is not filled in, subclause A shall apply. So what the parties had done by stipulating arbitration in London was operate the procedure contemplated by clause 19. And if your lordship says, well, the learned judge didn't consider these terms, I do respectfully suggest he ought to have done. And I'll tell you why.
Did you draw his attention to them?
Yes, I did. Yes, I did. He actually he quoted them, but didn't refer to them. Now, the point I'm going to make...
Well, you don't need clause 19 at all, do you? I mean, you've got clause 17 of the recap.
Yeah.
And once the subject's lifted, that's all you need. Be a different tribunal, because it would be a single arbitrator, but
yeah, well, exactly.
Cases have held that GA arbitration in London is a sufficient arbitration clause.
Without question, I'd like to think I'm as familiar with those cases as is your lordship. Absolutely right.
Much more so, I expect.
As.
Because I haven't looked at them for years.
well, as I would still prefer. But the point is that what you're construing is what the parties have agreed, and they have agreed that the standard terms of the charterers should be absorbed into the terms that they have agreed. So you set out the arbitration clause in accordance with sort of traditional construction routes. You put in the arbitration clause and then say, how does that tie in with the incorporating provisions?
Well, if they're rational businessmen, they're unlikely to want to have anything to do with a clause that says arbitration in Hong Kong according to the English Arbitration Act.
Yes, and that's why, as rational businessmen, they said London. In clause 17 anyway. Of the recap.
Okay, that's the arbitration clause.
Yes.
Where do
now,
we go from
but
there?
the point I'm making, my lord, is that it makes perfect sense in the context of the agreement as a whole, the fixture as a whole, whether it's binding or not, to say, well, they've agreed to incorporate the charterer's terms. The charterer's terms include clause 19, the arbitration clause. So in order to give the parties' agreement as to arbitration sense, you construe the recap telex and the terms and the incorporated terms together and say, right, it's arbitration in London, 3 arbitrators, the LMAA small claims procedure. It makes perfect sense. Now, what you you're looking at what the parties have agreed in the context of all of the terms that they've agreed. Now, the term that immediately follows the arbitration clause is in terms of its character no different. It is still a term which has been incorporated, and that's vessel nomination. And performing vessel nomination, clause 20, minimum 15 days before vessel arrival at the loading port, owner to nominate full details performing vessel, including ETA at loading port within mutually agreed 10-day lake hand spread, the tonnage coal to be loaded on board the vessel, and the vessel name along with particulars for shippers and receivers' approval, which is not to be unreasonably withheld within 2 working days. So when anyone reads that incorporated term in with the recap, one sees, well, actually it's reduced 2 working days to 1 working day following agreement fixing main terms and provision of relevant documents. So what the subject is doing, when you look at the contract as a whole, is just stipulating a different timescale. And then when the vessel owner nominates vessel as per clause 21, it shall advise the full charter party chain of the vessel to the charterer, including the vessel head owners and all disponent owners and charterers, together with other nomination details required. Charterer shall have the option to reject nominated vessel with reference to any charter party chain or lack of full information in the chain. And then
how can that have anything to do with a charter party for a named vessel? This is a charter party form for a vessel to be nominated.
To be nominated.
That makes sense. Right. But here, the vessel is the Newcastle Express,
which is basically nominated. Anyway, this is not the critical bit. Paragraph 21(2), vessels are to be acceptable to the charter and always in compliance with rules and regulations of the loading port. And then I think I can follow that. I can now go to 2 pages further on, clause 20.3 and 20.4. Acceptance of vessel, subject to clause 20.4, the charterer shall notify the owner in writing of the acceptance of the vessel within 2 business days from the receipt of a vessel nomination in accordance with clause 21 or 22.24. Rejection of the vessel, charterer may, acting in good faith, reject the vessel within 2 business days of receipt of the vessel nomination, including substitute, on reasonable grounds. Where a vessel is rejected, the charterer shall provide reasons for such rejection. So what the agreed terms were that there could only be a rejection of a vessel on reasonable grounds. My learned friend's case is that this term wasn't part and parcel of the terms agreed at all. I suggest all of the terms in the incorporated standard form of the charterers were incorporated unless specifically inappropriate. And I take the point that my Lord Justice Males makes about the present charter being not for a vessel to be nominated, but was for an actual nominated vessel. That I accept. But it's still the contract terms provided that you could only reject a nomination on reasonable grounds. And the arbitrator found that the rejection of the vessel, well, there wasn't a rejection of the vessel, but there were no reasonable grounds for rejecting the vessel. Now, that was not a point which Mr. Justice Jacobs felt it was necessary to consider, because he took a different view on the effect of the subject. But I say the subject has to be interpreted in the light of all of the terms agreed, and all of the terms agreed include you can't reject a nomination, you can't reject a vessel, save on reasonable grounds. But once again, if you would construe it like that, what on earth is the relevance to arbitration? Surely the person most equipped to deal with whether there has been a rejection on reasonable grounds is a commercial arbitrator. So it becomes less relevant to and less impeaching of the arbitration agreement. And so the question is whether, within the subject, the ability of the charterer to be unreasonable in a third party rejecting a vessel is itself a condition precedent to the arbitrator having jurisdiction to decide that matter. Now, the problem for my learned friend is that because of the terms of the fixture recap, all of the charterer's standard terms were incorporated unless specifically not applicable. And we've got two terms dealing with rejection of the vessel.
Well, isn't a clause about nominating a performing vessel obviously inapplicable to a contract for a named vessel?
No, because it may be that there are requirements for the vessel, whether it's chartered or nominated. On any view, the vessel is merely, so far as the suppliers are concerned, a nominated vessel. So, but parts of it may be. I wouldn't necessarily disagree with your lordship in principle, but the question is whether there is a term agreed, whether it's a contractual term, whether there is a term agreed that rejection of the vessel can only be on reasonable grounds, and if there is such a term agreed, whether, which should be determined by an arbitrator, whether the arbitrator is the party, is the person best equipped and agreed to resolve that issue. But you can't look at the fixture recap without looking also at the incorporated charterer's terms within that recap. Anyway, that is the charter.
So that's the first three of your 5 areas. How are you doing for time, given that?
I'm going reasonably quickly. I think I'm.
All right. Would you like to be a bit more specific about how long you think you'll need to?
No, I almost certainly wouldn't.
Well, you wouldn't like to, but I'm telling you to.
I'll finish by lunch, I hope.
Very good.
It's an expression of the. Can I just also mention the arbitrator found at in the award, which is at tab 8, he found by adopting at page 109, para 34, he accepted the owner's submission. This is at paragraph 53. He accepted the owner's submissions in paragraphs 34 and 35, and 34 is at page 104 going over to 105, where they found that it wasn't a reasonable, there was no reasonable ground for rejection. So that was a fact which was found by the tribunal, but which Mr. Justice Jacobs did not find. Now, your lordship, Lord Justice Mayo said, well, how does Section 69 work into it? The answer is a Section 69 appeal has to be on the basis that there was a finding of fact that the rejection of the vessel was unreasonable. That, of course, didn't feature in the learned judge's judgment, to which I am now going to turn, I hope with some speed. It's at tab 7 of the bundle 1. As I say, it's not disputed that the recap correctly set out what the parties had actually agreed. Page 60, the consideration is therefore of the legal framework at paragraph 79 and following. The consideration by the learned judge, it begins at section F at 76. And I think if we're at page 60 of the bundle, if I can just, at the risk of beating a dead horse, at the very top line, it says, in the present case, the parties were agreed on all the contract terms. That was the learned judge's conclusion. Now, section F deals with the section 67 application and discussion, and he deals with the legal framework, and he refers to Merkin, and he refers to, in passing, to Lord Hope in Fiona Trust. But what he does is he does not say, at the beginning, is what he should have done, where the parties have agreed an arbitration clause, I am to presume that they intended that arbitration clause to cover all disputes relating to their relationship, unless there are clear words or circumstances pointing in the opposite direction. He never started with that premise, and he therefore never addressed his mind to whether there was clear language or circumstances pointing in the opposite direction and impeaching or relating to the arbitration agreement as expressed in those agreed terms. He never did that. It was the mistake which underlay his subsequent reasoning, that he didn't set himself the proper criterion. What he seems to do is accept the proposition that they both stand and fall together, which is paragraph 78 and 79. And he then says, at paragraph 80, he said, well, Lord Hope in Fiona Trust contemplated that they could stand or fall together. But in my submission, when one fairly examines the whole of the speech of Lord Hope in Fiona Trust, you will see that what Lord Hope was there describing was an exception to the general rule. What Lord Hope said was, yeah, there may be cases where they stand or fall together, but there was absolutely no necessary reason why they should. And what Mr. Justice Jacobs has done is elevated an exception into, of what may happen, into the principle that they do stand or fall together. And he didn't. Therefore, he set out already on the wrong path. The fact that a matrix contract and an arbitration clause may stand or fall together does not mean that they should. And clear words are needed for that. And he didn't ask himself, are there clear words? He just didn't ask himself that question, that central question. He then says, at 83, well, to be fair, at 81, he does refer to Lord Hoffman, and he says he does refer to the fact that he indicated that cases where there is no concluded agreement wouldn't necessarily be attacked on the arbitration agreement. But that's to put the exception very much into a wrong context. He then considers the subject shipper's receiver's approval, and at 83 he says the starting point must therefore be for the court to consider and determine the effect of the subject provision contained in bold text at the start of the fixture recap.
Well, he's doing that, having accepted, apparently, your submission as to what the relevant question was.
Oh, yes, he accepted the relevant question, but he then says the starting point is the construction of the subject, rather than the starting point is the presumption of one-stop dispute resolution process, one-stop dispute resolution, and whether there are clear words to displace that presumption. And he then says it indicated, in my view, that that it qualified everything which followed. That naturally included the arbitration clause itself. Naturally he's there assuming what he's seeking to prove, that it does affect the arbitration clause. Naturally, one would ask, what is the shipper's approval of a vessel to do with the charterer's arbitration agreement? What has a third party's approval of a vessel got to do with the agreement of the parties to the charter to arbitrate their dispute? Answer, none. He just says it naturally follows. The answer is it doesn't naturally follow. The House of Lords in Fiona Trust said it didn't naturally follow. What naturally follows is one-stop dispute resolution, unless it's clearly displaced. So he's made the mistake of starting from the wrong starting point and then assuming what he has to prove as to what is natural. And then he, at 87, he refers to the commercial purpose of a subject of approval of the vessel. And the answer is, he says, it's obvious that the charterer doesn't wish to make a binding contract at all until both shipper and receiver have approved the vessel. But the terms he's agreed are approve the vessel not on unreasonable grounds. That's what the express term says in clause 20, and I accept the point that my Lord Justice Males makes. But he then goes on, without asking himself, why does approval of the vessel by a third party have any impact upon the arbitration clause? He never asks himself that question. He then concludes, just at the by the second hole in the page, a binding contract will therefore only come into existence and when the charterers communicate to the owners that the subjects are lifted. And that's why he placed emphasis on the use of the term lifting subjects, which I showed your Lordship. And then he says the straightforward conclusion is that the contract contained in the recap remained a non-binding contract or putative contract unless and until the charterers lifted their subject, which they never did. Then goes over the page to deal with separability. So he's so far addressed completely the wrong question. He then says, I accept it's still necessary to consider whether the effect of the subject is confined to precluding simply the main contract for the carriage of goods under a charter party, or whether it extends to the arbitration agreement of which it's intended to form part. I consider it does for a number of reasons. Now, these are his only real reasons. Once again, without referring to the presumption, without saying I'm looking for clear words. It says, first, paragraph 91, the effect of the subject is to negate the charterer's intention to enter into any contract at all unless and until the subject is lifted. That is circular. The legal consequence is that prior to lifting the subject, the charterers were free to walk away from the proposed contract since there was no contractual commitment. Given that this is the effect of the subject, there is no reason to think the parties intended any contractual commitment of any kind, including any contractual contractual commitment to arbitration. Where is his looking at clear words, clear language? It isn't. He just said, well, if it's the subject of a contract, then there's no contract, and that's it. And that's enough. But that is completely the cart before the horse. You should say that should be decided by arbitrators in accordance with the arbitration clause which has been agreed, unless there are clear words showing that they should not, the arbitrators shouldn't decide it. He doesn't address himself to the right focal point. He merely
sorry.
No, sorry.
I say if we are construing the subject as part of the section 67 exercise, section 67, not section 69.
Yep.
Do we need, as part of that, to consider whether that subject is to be read with clause 20 in the pro forma? Because if it is, as you say, that may be one thing, not to be unreasonably withheld, and that would therefore tell us something. But if it's not, then there is no question of not unreasonably withheld. It simply is subject to shippers' or suppliers' approval.
Well,
So does this come in? I mean, it comes in under Section 69, but I can see the way you're putting it. It may also come in as something we would need to decide under Section 67.
well, you've got to ask yourself, did these parties agree arbitration of the disputes arising out of their relationship, including the subject?
But in order to decide that, we need to form a view as to what the subject means.
Correct.
And the subject may mean different things according to whether or not it is to be read with clause 20 in the pro forma, and therefore do we have to form a view on whether it should be so read.
And you have been told by the House of Lords to look for clear language.
Only
If
when
all
you-
you could do is to say, well, it might or might not be, then that's exactly the sort of thing that should
Well,
go
that's
in.
that. Your answer there goes to how we should answer the question, but I'm asking, is that a question we need to determine?
It is a question that you need to determine from this point of view of, did the subject clearly exclude the jurisdiction of arbitrators to resolve disputes arising out of the relationship created by this fixture recap? That's the way I put it.
Okay.
It's does the subject relate to and impeach the arbitration agreement? And I respectfully suggest there is no rational basis on which they could, particularly when it is itself uncertain as to whether one does or does not include the incorporated terms of the Charter as standard terms. And if one does, there is then the limitation. How do you construe it? That's the paradigm of a Section 69, not a Section 67. So,
Mr. Young, if the judge was right that the legal consequence of the subject is that prior to lifting the subject, the charters are free to walk away from the proposed main contract, since there is no contractual commitment. If that's right, why do you need to apply a different standard to decide whether, nevertheless, there's an arbitration agreement?
because the question before your lordship is, what is the correct tribunal to decide that point?
Right. Okay, that's the question. I still don't understand why it means that I have to apply a different standard if the correct legal consequence of the subject
Because
the
it
charter
may
is
very
free to walk away.
because the court should not arrive at that conclusion at all. It's for the arbitrator to arrive at that conclusion, and if there is an error of law in the process of arriving at the answer, then it only goes under Section 69. It doesn't go to the arbitrator's jurisdiction to determine it and to find facts.
Yes.
So it's you say if the judge is right, the judge is not really the appropriate tribunal to answer that question in the first instance.
Okay.
So
If it is right, if an arbitrator was right to say that the legal consequence was that prior to the subject, the charters are free to walk away, if that's the right conclusion to draw by whoever draws the conclusion, then I don't understand why there is some different standard that has to be applied to decide whether that finding applies to the arbitration agreement.
no, it's not a different standard, it's a different inquiry altogether. What is the tribunal, which is the tribunal to decide this question? Is it the arbitral tribunal or is it the court? Or, as is contemplated by Mr. Justice Jacobs, well, it's an arbitral tribunal and a court in an inevitable two-step process. So you ask yourself, who decides it? I would respectfully suggest it's the arbitrator has jurisdiction to decide it, subject to appeal under Section 69, but it's not a Section 67 point, because as soon as you say it's Section 67, you are inevitably contemplating at least a two-step process. So it's what is the tribunal which should decide the issue. That's the best answer that I can give to your lordship,
because I think the premise of your lordship's question is, if I may respectfully say so, a false premise.
Fine.
No,
whenever it comes from the bench, Mr. Young, that's fine.
No, it's as with many questions of jurisdiction, it's who is to decide the point. One knows only too well that an awful lot of cases in the Lloyd's reports these days are about jurisdiction.
I'm conscious of the time, so I don't want to take up your time, but the point of my question was that you were saying, as I understood it, that the legal error here was that the judge didn't apply and I've forgotten the language you're using.
The presumption and the
clear words requirement. That's what I understood you to be saying was the error. And I'm struggling to see why that's an error in this case. But
well,
anyway,
it's what is the starting point determines what the analysis should be, and he started with the wrong starting point. And actually, I hope your lordships can see that actually reason 1 is circular. The effect of the subject is to negate the charterer's intention to enter into any contract at all. So it's as soon as you adopt that as a premise of the inquiry, then by definition the arbitration clause stands or falls with the main agreement, and that's precisely what's not to happen. It's an exceptional case, according to Lord Hope, I would submit. It's an exceptional case where they stand and fall together. So I hope that answers your lordship's question. One's always, when one sees a judge nod like that, one's always concerned that it hasn't answered.
I wouldn't worry, Mr. Young. I really wouldn't.
Well, I will worry that I'm not making my case as forcefully as I should. The second point is it was in bold. Well, that's putting style before content. But it also ignored what followed about certificates, which is rightship. And we all know, or at least an arbitrator, a commercial arbitrator, whether a commercial, or some judges would know, a commercial arbitrator would know jolly well what rightship is all about. So, but to put it in bold is just nonsense, with the greatest respect to the learned judge, saying that as a point. The third point is the separability. You don't create some sort of mini agreement. See ENCA. ENCA is about the determination of a proper law. It's got absolutely nothing to do with whether these parties agreed to arbitrate all disputes arising out of their relationship. And his fourth point is it was all in one document. Yes, of course it was in one document. It always is in one document.
Well, to be fair to him, that is a point which is made by Fiona Trust. I mean, both Lord Hoffman and Lord Hope.
That is true, but at the same time, they nearly always are. And in the Shell Time 4, it was in one document there. So it is a point, but it's not a point which is a point justifying the learned judge's conclusion. And I said that I had a couple of points to make upon my learned friend Skeleton. That was my fifth point, but I think I've run out of time and breath and energy, and I've not run out of will, but that's another matter.
All right, well,
would that be a convenient moment?
Yeah, are you concluding now, or are you wanting to think about it and have a couple of minutes?
Can I think about it? But I'm very conscious of your lordship's inquiry. I said I'd finish by 1, so you can take it that there's a presumption that I've finished unless there are clear indications to the contrary.
All right. Very good. 2 o'clock.